Good evening. I'm John Batchelor. This is the John Batchelor Show. Mary Kissel, the editorial board of the Wall Street Journal and the host of Opinion Journal, each day at 1:30 p.m. WSJ Live, joins me now. It was a very, very heavy news day. Mary worked hard at the Opinion Journal. I've watched her videos. I recommend them to you because we will be discussing one of the videos all evening, King v. Burwell, the decision 6-3 by the Supreme Court. Surprising in that Justice Roberts, heretofore understood as a conservative on the court, wrote an opinion that at this point you'd have to say is, among other things, creative, dealing with the language of King v. of the Affordable Care Act. There are 7 instances, I know this from Justice Scalia, who wrote a dissent, in the Affordable Care Act, where there is a reference ambiguously to exchanges, state exchanges, not the federal state exchanges, but the state exchanges. The presenting issue was, does the court affirm that this is the law of the land, given the ambiguity of the language, and that many states, majority of states, have chosen not to set up their exchanges to defy the federal government, in which instance the federal government, on a ruling of the IRS, it's hard to believe we know all this, Mary, has decided that they can pay subsidies in those states, even though it doesn't say that in the Affordable Care Act. The decision, 6-3. Mary, you had a conversation with your colleague, Joe Rago, the editorial board, and Joe's opinion is that Justice Roberts has made history here. He has created what is not in the law. We can't find it in the law. This stands now. I want to look at this in terms of the day after. Has the world changed? Have we lost something? Have we been damaged in some fashion? How do you see it, Mary?
Oh, I think we absolutely have been damaged, John, because there is no ambiguity in the phrase established by a state. The law is very clear. The subsidies are only supposed to go to exchanges established by a state. And effectively, what Chief Justice Roberts did is to say, well, I don't like that, and I'm going to amend the law to say established by a state and maybe by the federal government, too. So he read something into the law that didn't exist. He took on the role of a legislator, which is not what he is. He is a jurist. He exists in a different branch of government, and by making a decision like this, he corrupts the sharing of power, the checks and balances that make our democracy healthy and vibrant and that have sustained us for several hundred years. So it is a sad day for American democracy.
Justice Scalia wrote a dissent, a very colorful dissent, great fun to read, but in it he, among other things, cites the fact that Alexander Hamilton, on the $10 bill for a few more years, Alexander Hamilton, as Publius, publishing in the Federalist Papers, identified that the court was not to do more than to rule on the law. It was not to create the law. It was not to act as the legislature. In that, Justice Scalia has very firm ground to say this is exactly what is not to happen. And yet here we are. It has happened. But John, that's been happening for decades. That started with the civil rights movement. It happened in the 70s, most particularly. We've been writing a lot about this on the editorial page. We had a second decision, in fact, today that rested on these yes, we'll
ideas.
Get to that in a moment. Though.
Oh, sorry.
It's fine. We're pointing ahead. It's
it
fine.
Was the salsa music, John. I was moving quickly.
We're pointing to the fair housing. It's coming up. Let's move immediately to it because there is much more to say about the decision by the Supreme Court. There are politics. Imagine that, politics in Washington. And both sides are now reorganizing themselves. There was a statement by Jeb Bush earlier today saying that he intends as president to repeal and replace. Mrs. Clinton put out a statement saying we have to fight the Republicans who are trying to take away health care from X number of millions of Americans.
Well, here's the funny thing about the president's statement and Hillary's statement. So the White House came out and said, isn't it terrific that we have millions of more people covered by Obamacare? That's a real victory when you have premiums going straight up. So is it a victory if you cover more people with substandard care and the cost of health care becomes prohibitive for millions and millions and millions of other Americans? It's such a funny thing, John. It's a funny way to measure success.
Fair housing. this is a question turning on the very careful term disparate impact. Mary has talked about this over these last years, especially, Mary, you pointed to the Housing and Urban Development making a ruling, just imposing a ruling of what disparate impact is. This can get a little lost. I took my notes from your conversation with a Heritage Foundation scholar. However, what I presumed from the conclusion that you two were going back with intimate knowledge of these cases is that not only is this a surprise in that it endorses a decision by HUD, but it creates an environment in the future that will be much more complicated and probably not commonsensical.
Well, look, there is a question, a constitutional question. Is it constitutionally legal to sue someone for unintentional discrimination? Now, we have different discrimination laws in America. Some apply to employment, others apply to housing. In employment in the 70s, the Supreme Court decided that this was an okay thing to do. They just made up the law, much as Chief Justice Roberts did today with his interpretation of the Obamacare federal subsidies. So the court today said, well, we've never said that it is constitutional to sue for unintentional discrimination in housing decisions. But since we made up that law in employment in the 70s and said that it was okay to enforce under Title VII of the Civil Rights Act, then we're going to make it up today and apply it to this other law, the Federal Housing Act. So again, John, a really sad day for American democracy, but particularly for the probity of the Supreme Court, which is supposed to read laws and enforce them based on their text. I mean, these guys are just making this stuff up out of thin air.
I read, because you directed me to it, Mary, in your piece, Justice Samuel Alito's dissent. And I think I have this correct. He proposes a very real case that is imminent if it hasn't happened already. You get credits for housing. A municipality gets credits to award for housing here or housing there. There are two neighborhoods. One is a poorer neighborhood, poorer income neighborhood, and another one is a well-to-do neighborhood. If the municipality decides to give those credits to the poorer neighborhood, the well-to-do neighborhood can sue under disparate impact. If it decides to give them to the well-to-do neighborhood, the poor neighborhood can sue. And if it decides to divide them in half, Solomonic, both sides can sue, is his interpretation.
Well, the irony of this, the perversity of this, is that the 1964 Civil Rights Act was meant to protect equality under the law, so that the real intent of it was to say, to protect a black man in the South from a homeowner who said, I'm not going to sell this house to you because you're black. But that's not what happens today. That era is gone. So what you have are federal bureaucrats who look at the suburbs and say, we want to be utopian social planners, and we want to color code the suburbs, and we want to tell Westchester County, New York, which is what they're doing right now, a separate case, that they should have X percent of Hispanics, Y percent of blacks, and A percent of whites. So think about that, John. That is extremely scary. Instead of saying, you know what, we need to figure out how to help poor people of whatever color and circumstance. We need to figure out how to empower them to help themselves. How do we get them? How do we help them get better educations? How do we encourage a more prosperous economy so that there are more jobs for these people to take, so that they can work their way up the income ladder and to move into neighborhoods they can afford? That's the real question. That's the real problem. But instead, what you have is the federal government spending your tax dollars pursuing a legal theory that says we want to be able to sue people for unintentional discrimination so that we can tell you, the American people, where we want certain people to live and maybe to live in your neighborhood or somebody else's neighborhood. It's absolutely backwards.
Finally, we must tuck in your conversation with James Freeman because it points to the new presidential candidate for the Republican Party. This is Bobby Jindal, the twice governor of Louisiana. uncomfortably unpopular in Louisiana right now because he's being hard about cutting schooling and health care, which is very uncomfortable for the people, and that he gets a lot of rejection for that. But you made the point that he's a leader in school charters, that Louisiana's a leader in school charters.
Yeah, I think it's easy to say people in Louisiana hate Bobby Jindal and Louisiana is a poor state. Yeah, that's true. At the same time, there are a lot of people in New Orleans who love Bobby Jindal because they are at the forefront of the school choice movement, and there is no other governor in the country that has done more to lift up poor communities and to give educational opportunities to poor, mostly minority students than Bobby Jindal has. And on top of that, when I was talking to James Freeman today on the show, he pointed out that Bobby Jindal has had very, very extensive experience in the healthcare sector, both in Louisiana but also in Washington. So that could be an advantage
for entitlements, for reforming entitlements.
That's correct. He could have an advantage there in the
Presuming
race
a better day for the next president of the United States. Mary Kissel, the editorial board of the Wall Street Journal, and that was just a piece of the news today. We haven't done it all. We're going to do what we can tonight. The Iran deadline, everybody remembers, is June 30th, and I will get to that later tonight. What does it mean? There was an open letter sent out from distinguished scholars, including people who have served the President of the United States, advising the President not to do this deal, if and when and how. We'll discuss that later tonight. Also, more about I'll speak to Mary's colleague, Dan Henniger, about the federalization of everything. You know, the Internet of Things. This is the federalization of things. Mary Kissel, I'm John Batchelor.